Ladies and gentlemen, thank you for standing by. Welcome to the Civil Rights and Housing Advocates speaking on the Fair Housing Supreme Court case. At this time, all participants are in a listen-only mode. Later, there will be an opportunity for live questions and comments. Instructions will be given at that time. As a reminder, this call is being recorded. I would now like to turn the conference call over to our host, Sherilyn Ifill, President and Director, Counsel of the NAACP Legal Defense and Educational Fund. President Ifill, please go ahead.
Thank you so much, and thank you all for joining us for this very important discussion. I'm going to speak for a few minutes, and then we'll hear from two other speakers who joined us today, and then all of us will be available for your questions. So I'm going to speak first, and then we'll hear from John Railman, the managing partner at Railman, Dane & Colfax, who's here on behalf of the National Fair Housing Alliance. And then we'll hear from Dennis Parker, who's the director of the Racial Justice Program at the American Civil Liberties Union. The case that the Supreme Court will hear next week is the third time in 4 years that the court has sought to hear a case dealing with the question of whether disparate impact claims are cognizable under the Fair Housing Act. The court has sought to hear this case and sought to hear two others before it, despite the fact that there has been uniform interpretation of that question by every appellate court to have considered the issue, and despite the fact in this case that there is uniform interpretation by HUD, the agency assigned to manage the Fair Housing Act, and despite the fact that HUD has recently released guidelines describing what the obligations are of communities under the Fair Housing Act. This case and the court's aggressive desire to hear this particular issue is important because, without question, the court is poised to do damage to a key means of vindicating claims under the Fair Housing Act. Why is the Fair Housing Act important? In some ways, it gets the least attention of the major pieces of civil rights legislation that were enacted in the 1960s. But the Fair Housing Act is a critically important element in the panoply of civil rights legislation that really began to change the shape of this country. You probably know that the Fair Housing Act was passed immediately after the assassination of Martin Luther King, and so it's fitting that today, on the actual birthday of Martin Luther King, that we'd be having this conversation. As cities all over the country were enveloped in unrest and riots, Congress took up the Fair Housing Act and despite delays that had happened prior, worked diligently to get the act passed within a week of Dr. King's assassination. The Fair Housing Act was seen as critically important because it reflected a recognition by Congress, by leaders throughout the country, and by the then President of the United States, Lyndon Johnson, that segregation lay at the core of many of the issues of racial inequality and racial injustice in this country. And it was a recognition that segregation, not only formed by the intentional acts of individuals who refused to provide housing on an equal basis to African Americans, but also the effects of long-term policies and practices by the federal government, had created a society that the Kerner Commission called two societies, black, white, and unequal. The Fair Housing Act was a forward-looking act. Congress intended not only to deal with what had happened in the past, but also created an act that was designed to ensure that there was a means to deal with how the effects of past acts would play out in the future. Part of the story here in terms of the court's interest in this case can be seen through the lens of the way in which the court dealt with the Voting Rights Act 2 years ago. You recall in that case, the court essentially damaged a key provision of the Voting Rights Act, Section 5, because of the court's unwillingness to recognize the ongoing need to have some federal accountability over southern jurisdictions as it relates to voting. The court refused to accept that these protections and provisions were necessary for minority voters. And yet we have all seen over the last 2 years how wrong the court was. This is because what we have seen is this court's insistence on a vision of discrimination that is backward-looking, that recognizes only the crudest forms of intentional discrimination that we're familiar with from the 1960s and 70s, but the court's difficulty with grappling with contemporary forms of discrimination. And this case is an important one because the disparate impact standard allows us to deal with the contemporary manifestation of housing segregation and housing discrimination. And so we once again face a situation in which the court has to grapple with how do we deal with discrimination and segregation today. Ironically, this comes at a time when our nation is rife once again with racial unrest. And that racial unrest is due to many causes. But without question, one of the causes remains the ongoing issue of housing segregation. Precisely at this moment, when HUD has issued a regulation focused on one of the key obligations articulated in the Fair Housing Act, the obligation to affirmatively further fair housing, we now have guidance from HUD on how to develop that doctrine and how jurisdictions ought to put real teeth to the doctrine of affirmatively furthering. We're therefore poised at a moment when the Fair Housing Act could really be robustly enforced in a way that it never has in the past. And this is precisely the moment when it's most under peril. And so we hope, and by this briefing and by this conversation, that you'll have an opportunity to understand what is at stake in this case, why what happens in this case, both at the oral argument and, of course, ultimately in the decision, is related to the ongoing issues of discrimination and segregation that we are seeing in our country every day, and why the arguments that are laid forth in this case are deeply relevant to the future of our country as it relates to racial equality. And with that, I'll turn it over to John Relman.
Thank you very much, Sherilyn. I want to pick up where Sherilyn left off and talk a little bit about how the disparate effect actually works and a little bit about how it comes about in this case. As Sherilyn said, the Fair Housing Act was passed for the purpose of dealing with both intentional discrimination, that is conduct that's intentionally discriminatory in its purpose, but also to deal with the effects of discriminatory policies that end up perpetuating segregation, that have left us essentially with a deeply segregated society. Many policies around the country over the years, like the one that's at issue in Texas today, in this case before the court, may not have been designed with the express purpose of being intentionally discriminatory, but they have the effect of perpetuating segregation, of perpetuating the effects of a deeply segregated society that have resulted from intentional discrimination. Whether there is intent behind those policies or not, the outcome is functionally equivalent to intentional discrimination. So let's just take, for example, the policy that's at play in Texas. If the system that Texas uses to decide where it's going to place affordable housing in the state results in most of the affordable housing being put in poorer communities of color, where schools suffer, where crime is high, where the community is blighted, there's no chance for working families to move to communities of opportunity where there are good schools or better employment opportunities. And when I say it's functionally the same as intentional discrimination, what I mean is the outcome is the same as if the white communities passed a discriminatory zoning ordinance that said African Americans can't live here, or people of less means who are disproportionately African American can't live here. It's the equivalent to intentional discrimination. And that perpetuates segregation and racial and economic inequality, and this is what the Fair Housing Act was designed to address. Now, let me get to the effects test. So the effects test has been one way that the courts have said is appropriate under the Fair Housing Act to deal with the outcome of these policies, not just with the intentional discrimination, but with the outcome. And it's been very successful in doing that, and I want to talk for just a minute about why. For 40 years, the courts have, as Sherilyn said, resoundingly endorsed and affirmed the use of impact under the Fair Housing Act. And I think the answer is because it both not only makes sense for the purpose of the Act and what it's trying to achieve, but because it works, and it works in a very reasonable way. Let me begin by saying what it is not. It is not a gotcha, as people perhaps on the other side of this case and other side of the civil rights community would like to say it is. They say it's just about numbers, and if there's an adverse impact from a policy, that then you're guilty of discrimination. That's not the way the effects test works. If a policy has an adverse impact, as in the Texas case, that's just the first step. The next step is that the defendant, in this case the state of Texas, has to show that the policy is justified. And if they do that, then the attention turns to where the real focus is. The real focus under an effects test or standard is there a less discriminatory alternative that will provide for the very same needs or justification equally well that the state or a private business has set out. And as I say, that's where the focus is. If there's a fairer way of doing it, then you need to do it. If there isn't a fairer way of doing it that achieves the same goal, then you don't. This has forced us to be better on both sides. It's forced us to focus on whether you're on the side of a government or on the side of industry or on the side of advocates for civil rights. It has forced us over these 40 years to be better at doing what we do. We come up with better policies that achieve the same goal equally well, but are fairer, that have less impact on protected groups. Take, for example, the lending industry. The lending industry over these many years has been able to design better underwriting and pricing policies that end up actually qualifying more people so they make more money but have less impact on protected groups. So in that sense, it's good for everyone. It's made us better. It's created more opportunity for people who are qualified. We get to a fairer system for everyone. In light of that, every single court of appeals, virtually every single district court that has addressed this question has said, not only is it consistent with the purpose of the Fair Housing Act, but it's a reasonable approach, a reasonable policy, and it makes sense. Why would we strip this standard from the Fair Housing Act? I would suggest that if the court does that, it's going to make it harder to address the harms caused by intentional housing discrimination, and it's going to make it harder for us to get to better outcomes that will work for everybody, to make us a less divided society, a less segregated society, a society with fewer disparities, both in terms of racial and economic justice. It's going to set us back if we strip the standard out, because inevitably it's going to undo the progress we've made in battling the effects of segregation that have improved situations and led to better racial and economic equality in cities and communities across the country. Yet because we still have serious divides in cities around this country, we still have deeply segregated communities, we still have economic inequality and racial inequality and opportunities that are so different in communities around the country, that this tool is still vitally important. It's not the case that we are now in a post-racial or a post-inequality society where we don't need this tool anymore. We very much do. So let me just finish by saying that our work under the Enforcement of the Fair Housing Act will be much harder without this tool. We'll still be able to do it, but it is going to be much, much harder, and we will unravel a lot of the progress we've made for no good reason. The stakes are high because, as Sherilyn said, let me just end with this, the stakes are very high because it's my belief that housing, and I think it's a belief that's shared by many advocates and many people who work in the area of civil rights, that housing lies at the fulcrum of civil rights. Where you live affects the opportunities that you have for jobs, for better schools, for connections that allow you to have opportunity in your life to advance. And if we cannot use the Fair Housing Act to address the policies that affect and limit where we live and that affect the opportunities that people of color will have, our ability to protect all of these civil rights, employment rights, rights to a fair and equal education, our ability to protect these most basic civil rights of those who are underserved will be seriously undermined. Let me turn it over to Dennis at this point.
Thank you, John, and good morning. I'd like to amplify a little bit both what Sherilyn and John spoke about and talk a little bit about the scope of what is at issue here that the court will hear next week. The importance of the disparate impact standard is evident both by the wide range of individuals it protects and the parties and the institutions who would benefit from its elimination. The types of parties who rely on the protection provided by the disparate impact standard often include those who are most vulnerable. Those who seek its elimination are often the most powerful with the greatest resources, and this group includes many who actually profited from practices which unnecessarily harmed members of protected classes. We've heard some discussions about the group that has been primarily affected by this nation's history of housing discrimination, and that is discrimination based on race and ethnicity. But in fact, the groups that are protected go beyond that. They include victims of domestic violence and sexual abuse, who are statistically overwhelmingly women and children. And this group faces the possibility of eviction under rules by landlords or municipalities, which penalize residents of houses where crimes are committed or the police called. This often places women and children in a difficult position of having to choose between calling the police to deal with the abuse that they're suffering or facing the possibility of eviction because they called the police. Other facially neutral rules that have a disparate and unfair impact are requirements by landlords that residents have full-time jobs before they can apply for housing. That thereby eliminates disabled veterans, single mothers receiving child support, people with disabilities receiving Social Security. And this is a perfect example of what John discussed about the way that a disparate impact standard can help make a rule both more fair and more effective. The purpose of the landlord imposing that requirement would be to make sure that they will get paid for the rental for the building. You could achieve that in ways that protect the valid concerns of the disabled veteran, of the single parent, and at the same time assure that the landlord receives reimbursement for housing. And throughout each of these examples, a similar calculation can be made. Even the facially neutral practice of limiting bedroom occupancy has a disparate impact. In a case in Stamford, Connecticut, a couple who lived in a one-bedroom co-op faced either a $500 monthly fine or the possibility of being forced out of their apartment because they were having a baby. And without the disparate impact standard, it would be difficult or impossible for them to challenge this facially neutral practice. At the same time, the elimination is pushed by mortgage companies, banks, insurance companies, many of whom engage in or are benefited from predatory subprime lending practices. Which depended upon marketing high-risk loans to communities who were deprived of conventional lending opportunities historically. The lack of access was the result of decades of redlining, segregation, and failure to provide services to communities of color. This resulted in the disproportionate incidence of foreclosures in those communities. At the same time, though, financial institutions who benefited from the exorbitant profits that were made during the housing bubble also benefited from government bailouts when the bottom dropped out. and so didn't suffer the effects of the situation that they helped to create. Despite this history, these institutions argue for even less oversight and fewer opportunities for people seeking fairness to get redress in the courts. And as John mentioned, the argument that's heard most often is the gotcha argument. But as he pointed out, that this is not an attempt to create new standards that would bind these institutions, but a way to continue a time-tested and effective standard that's used by every enforcement body and approved by every circuit court over the last few decades.
Great. Krista, we can go ahead and open it up for questions.
Thank you. If you would like to ask a question, please press star 1 on your telephone keypad. Again, that is star 1 on your telephone keypad if you would like to ask a question.
And we'll take a first question from someone in the room. And please say your name and what outlet you're from.
I'm Greg Storr with Bloomberg News. Settlements, of course, made the first 2 cases go away. Have you or have your allies taken any steps to try to make this case go away, perhaps by encouraging the group that's pressing this lawsuit to withdraw its complaint?
I have not.
Okay, next question. Krista, do you want to take somebody?
Absolutely. We'll go ahead and go in with our first question in the queue. This is coming from James Schultz. James, can you let us know who you're with?
Yes, I'm Jim Schultz with the Dallas Observer.
All right, go ahead.
Mr. Parker describes the parties who are interested in defeating the disparate impact, but I wonder, there's a case here in Dallas that I know Mr. Relman knows well, in which HUD had brought a complaint against the city of Dallas and settled that complaint recently in a way that most people here interpreted as a dramatic retreat on HUD's part. Our impression here was that HUD is a divided house where disparate impact is concerned. And I wonder if either Mr. Relman or Mr. Parker could address the question of whether this administration is truly on board with the defenders of disparate impact.
Sure. This is John Relman. I can't. I'm not in the White House, so I'm not in the government, so I hardly speak for the government. But I think the only thing I can do is observe what they have done and what they have supported. The HUD regulation is a ringing endorsement of disparate impact. It carefully reviews the case law and the decisions and all the arguments and all the comments that have been made on all sides of the question, and concludes that disparate impact is properly a part of and a standard that should be used under the Fair Housing Act. And that was something that was strongly supported by the President, by the White House, by the Justice Department, and by, of course, HUD drafted it. So I think that it pretty much speaks for itself. That is the clearest message that can be made. But by the same token, I think that you have to also look at a broad range of the enforcement actions that this administration has taken over the last 6 years, whether it's in the fair lending area, where they have robustly endorsed the use of disparate impact along with intentional discrimination in enforcement actions. The Justice Department has, the Civil Rights Division has won unprecedented decisions and settlements in the area of fair lending. The same is true with the CFPB, the Consumer Financial Protection Bureau. It's robustly endorsed the use of impact in all of its work, its supervisory action and its enforcement action. And you can walk that down to all parts of the government. So I don't think there's any question that HUD stands firmly behind disparate impact. I don't think there's any divide there, and I don't think there's any divide in the administration. Dennis, I don't know if you want to...
Yeah, the only other thing that I'd add is that there is a history of Congress declining to to get rid of the disparate impact standard, even though efforts have been made really since the act was passed. And in fact, there were some exemptions that were included in the law in one of the years when it was amended that would only make sense if they expressly had planned on continuing disparate impact. So the level of unanimity that John described really extends through the federal agencies and through Congress.
Thank you.
We'll take a question from the room, Krista.
Hi, Jeff Braven of Wall Street Journal. If the court rules against the doctrine in this case, would it have implications for other aspects of civil rights law, such as employment or education and other areas?
Yeah, so, I think that I don't think it's going to affect anything in the employment discrimination area. The Congress back in 1991 amended the Title VII to make clear that disparate impact is a part of that law. I think with respect to education, again, there have been decisions with respect to Title VI that have spoken to this. So I think, it's very hard to predict how what the effect of the Supreme Court decision is going to be before it comes down. But, I don't have any reason to believe that this is going to go any further than the Fair Housing Act itself.
That being said, of course, what the court says is going to be the most important because, how the court describes the ongoing salience of disparate impact, even in other arenas, will be important. And so the language that they use, the explication of their, difficulties or objections to disparate impact or, God willing, upholding disparate impact in this context, will matter. And so it's not a matter of is it up or down and then everything's in the clear. It's really what is this court prepared to say about disparate impact, and how do we take that language and understand it, and how will appellate courts take that language and understand it as they engage disparate impact in other contexts.
Can I just follow up? Isn't the language in the Equal Credit Opportunity Act very, very similar to the Fair Housing Act? Isn't that at least one statute that would be affected?
No, I don't think necessarily so. I mean, again, I agree with Sharon. It depends very, very much what is said. The language is different, and there are important differences with the Equal Credit Opportunity Act. The Fed has spoken for a long period of time. The language is different. The history is unique. And so, and of course, the timing of when the act was passed and the guidance was given is different. There's different circumstances. So you can't predict what's going to happen, I don't think, or opine on it in any meaningful way. I agree 100% with Sherilyn. I mean, it depends very much what the court says. The court has the ability to speak broadly on the issue, to speak narrowly on this case, and where they go with it is going to be very, very important.
We can take a question from one of the folks on the phone, Krista.
All right, we'll go ahead and take our next question. This is coming from Richard Wolff with USA Today. Richard, please go ahead.
Hey, thanks for doing the call and the briefing. And I came in a tiny bit late on Sherilyn's comments, so Sherilyn, you might have addressed this. But can you or any of the speakers talk a little bit about the court and what you kind of expect, given the voting rights decision a couple of years ago, and given the fact that they keep trying? This is the third time, I guess, to get to a Fair Housing Act case. Is it clear to you? I mean, would it be a real long shot for you to win this case?
Well, I don't think we can kid ourselves that the court is not aggressively interested in this issue. In fact, taking the cert questions in this case, the court had two questions before it. One was the question of whether disparate impact is a cognizable claim under the Fair Housing Act, and the second question was, and if so, what are the standards? And the court wasn't interested in the second question, only in the first question. We also know that, the Magner case from several years ago, the Mount Holly case from 2 years ago, and now this case suggest that there are at least 4 members of the court that are particularly interested in this issue. And given the unanimity that we've all described, the unanimity among appellate courts, the unanimity with Congress, the unanimity with the agency, the question then has to be asked, why is the court taking this case? And I don't think that's a non-story, by the way, because as we have all these conversations about impartiality and balls and strikes and all that good stuff, it's significant to me when the court makes a decision about taking a case about which there is not appellate controversy. And about which there is the kind of unanimity that we have described. So this is, and takes the question presented in a way that suggests, what it is interested in. So, of course, that's the court's prerogative, but we should at least be clear about what is happening. So what I had said earlier, Richard, was really about the way this can be in some way seen as of a piece with the way the court approached the Voting Rights Act issue. And what I was suggesting was that, it is 2014. There are, without question, many instances of intentional discrimination across a variety of areas in our country. There is intentional housing discrimination. Many of us may recall that, we were just talking about this less than a year ago during the Donald Sterling controversy, the former owner of the Los Angeles Clippers, who, aside from his very colorful and racist remarks about who he didn't want to attend his games, had been the subject of 2 cases under challenging housing discrimination in which, the actions that he was accused of involved intentional discrimination, and his views about African Americans and housing and his views about Koreans and housing and so forth. So those instances exist. But much more prevalent in 2014 are 2015, heavens, are 2 other kinds of discrimination. and they are, one, the ongoing effects of past discrimination that has kind of locked us in place, and discrimination that does not appear intentional on its face, but that essentially uses the cover of what would look like non-discriminatory qualifications to kind of mask discrimination. And that's considerably harder. And I think that that's where we are in terms of thinking about what the court grapples with and has trouble with. So the court has no problem in the voting rights context crediting and understanding the history of voting discrimination in a variety of jurisdictions that were raised in the Shelby County case. Accepting that discrimination continues to exist and that the effects of that discrimination continues to exist and is relevant was harder for the court to accept. And instead what the court felt was that essentially the Section 5 of the Voting Rights Act was kind of stigmatizing Southern jurisdictions and holding them in place in a history that no longer has any relevance. And what I'm suggesting is that here again, when we're looking at disparate impact, we're really looking at what is the most prevalent modern iteration of housing discrimination. And like the Congress that passed the Voting Rights Act, the Congress that passed the Fair Housing Act was forward-looking. They recognized that they weren't just trying to get at the discrimination that existed in the moment, but they recognized that housing discrimination in particular is perpetuated and was perpetuated not just by the individual acts of individual people who are racist, but was created essentially by a set of policies, broad-based policies and investments, mostly promulgated by the federal government beginning in the 1930s, that locked into place the housing segregation that was so prevalent in 1968 and that in many instances is still prevalent today. And the Fair Housing Act was meant to provide the means to deconstruct that, to affirmatively further fair housing. And what the framers of the Fair Housing Act understood fair housing to be was housing that would promote integration. All of the language, all of the discussion surrounding the Fair Housing Act is about the evils of segregation and the ways in which segregation was actually the cause of many of the problems that we saw in the country. And the reason it was passed so quickly after the assassination of Martin Luther King and in the midst of that unrest was because many members of Congress believed that the unrest that we saw was a direct result of segregation. So the idea of integrated housing is the animus of that lies at the core of the Fair Housing Act. And what the framers wanted was to create a construct that would allow in the future the opportunity to ensure that we did not hold in place the frame and the structures that created the segregated housing that we lived with in 1968. So that's what this Supreme Court has to grapple with. And the question is, can they? Are they prepared to understand that discrimination as understood by Congress in passing the Fair Housing Act is not just the discrimination of individual bad actors who don't want to, sell their home to someone or don't want to rent their home to someone, but that it is also the effects of the discrimination that we lived with in the past. The question we then have to ask ourselves in the context of Texas, for example, is how much of a difference does it make that the low-income tax credit in Texas for 15 years was only targeted at minority census tracts and that essentially produced, in essence, the same result that the de jure segregation rules in Dallas produced in the prior period when all of public housing was 95% in majority African-American census tracts. The result is the same. And so then, as John says, what the Fair Housing Act says is, well, we're looking at this impact. Is there a less discriminatory means? Is there another way to do what you are trying to accomplish without embedding in it and holding in place the segregation that has existed in this community? And the question is posed, and if the answer is yes, then do that. Then that is the better alternative, the fairer alternative. If the answer is no, then it's no. Then you don't have to change anything. So I think it's important to just understand that, particularly in light of the moment we're in this country, is that we need to be able to get our hands around what discrimination looks like outside of the context of individual bad actors. And we need to actually credit the vision of the framers of the core civil rights statutes who understood that they were trying to create something that was forward-looking, that would give us the tools that would last beyond the period in which overt racist acts or racism was socially acceptable.
This is John Relman. Let me just jump on something that Sherilyn said and piggyback on that, because I think it's very important to get to actually what happened here. So the Texas case is really about creating an ability to move to opportunity. That's what this is about. It's about creating an opportunity for folks to use their vouchers to move to a community of opportunity, in this case, a predominantly white community. What actually happened in the case was that the Fifth Circuit, the Court of Appeals below, ruled for the plaintiff in this case, ruled for the Inclusive Communities Project, and said, yes, we see this as the functional equivalent of preventing people from moving to opportunity. But the answer, what the Fifth Circuit said, was not a bastion of liberalism, I might say. The court is actually considered to be fairly conservative. But what they said was, they said, we defer to the HUD regulation on impact. So impact is okay. It's a standard appropriate under the Fair Housing Act. But they didn't say, yes, Texas is guilty. They simply said the burden now shifts to the plaintiff to provide, to determine or to show that there is a fairer way to design the system so that these vouchers can be available more fairly across the state of Texas in all communities. And all we're doing is saying, plaintiffs, come forward. If you can show that there's a less discriminatory way to do it, fine. If you can't, then Texas can proceed with doing what it's doing. And it's only that which was decided below. Now, in the face of, as Sherilyn said, no Circuit Court of Appeals in the country having said anything to the contrary, and in the face of Justice Scalia himself, who has issued rulings saying that we need to defer to the agencies like HUD that are charged with the enforcement of the statute, and therefore we defer to them in their interpretation of the statute that they're charged with enforcing, in this case the Fair Housing Act. Nevertheless, we have the court taking this case. And you have to ask why, as Sherilyn says, why is the court taking this case in light of that procedural history and in light of the fact that there is no disagreement? That's what is of concern. And it's a greater concern because the outcome below was so eminently practical and reasonable it was making everybody better at doing what we do. It's saying to Texas, if you can, let's see if we can find a better way. And in fact, the process started down below where Texas started to redesign their selection process and found a fairer way to do it, but that got stopped short right now because the court is taking this case. So that's why I say I think that if this case does go the way that we would not want to see it go, it will be a step backwards. It will hurt our efforts to constructively deal with the effects of de jure segregation, de jure discrimination.
Jess Braven here again. I'm not an expert in the regulations, but isn't the state also obligated to target some of this money to low-income areas in order to promote development in them? Isn't there a tug of war between those two objectives? And in the state, isn't that part of their defense that they have to target those tax credits to underserved areas as well as try to do this, moving to more affluent areas?
Yeah, that is part of what the Texas asserted in the case below, but that's why it turned to the court, recognized that, but still moves to the final phase, which said, look, if the plaintiffs can show that consistent with that obligation under the tax credit policy to target in the way that's required in the law, there's a fairer way to distribute these tax credits, then you need to do it. And that's reasonable. So it's taking into account and giving validity to the defendant's position, but at the same time saying, under this standard, if there's a better way to build the mousetrap, we got to do it.
I think there's also something to be said for, really peeling back a little bit this assumption about how the application of these tax credits would produce the revitalization that Texas suggests they wanted to happen in low-income communities. There isn't really evidence that is the way to produce revitalization. Revitalization happens when you have mixed income within traditionally low-income and poor areas. And so, in fact, I think that it's worth interrogating the idea that is how revitalization happens.
And there are so many examples of successful programs that try to create opportunity for low-income people to move into less segregated, less poverty-concentrated areas. So there is a lot of support for the validity of the use of this money to increase diversity and reduce poverty concentration.
I mean, one example of that, again, John, one example of that is St. Bernard Parish in Louisiana. Just to the northeast of New Orleans, there was a legal battle over the placement of tax credit properties in St. Bernard Parish, which had a history of excluding African Americans, a long history of excluding African Americans, 96% white. After a long legal battle that included both disparate impact claims and intentional discrimination claims, in 2012, the local court down there issued rulings that ended up with affordable housing, mixed-use housing, very much the kind that John is referring to, being built in St. Bernard Parish, which has now integrated that parish and has resulted in very successful integration of housing there. The community is actually extremely supportive now of that housing after having resisted it. So it's a perfect example of successful use of both tax credit policies and impact litigation to create opportunities for underserved communities in color.
And in a very close example, in Baltimore, in a case that was brought actually jointly by the Legal Defense Fund and the ACLU, we've seen incredible progress in the use of vouchers that permit Baltimore residents to move into high opportunity areas. And as John said earlier, this is a really important thing because it's not just a question of having a roof over your head or of living even in an integrated neighborhood. It's also a question of having access to good schools, to the food and the environmental advantages that neighborhoods frequently have. And it also implicates the question of wealth, which we haven't spoken a whole lot about this morning, but in fact one of the consequences of our history of segregation and discrimination in housing has been the enormous wealth gap between communities of color and white communities. And that is a direct result of that prior history of discrimination. Fair housing not only affects what happens to you now, but it affects what happens to you and your community and your descendants in the future, because it makes it possible for you to accumulate the wealth that makes it possible for you to enjoy full participation in American society.
And I would add to what Dennis said that, discrimination, housing discrimination, is not something that's effectively combated on a house-by-house basis. Discriminatory policies, or policies that have the effect of discrimination, have to be dealt with on a systemic basis. And the effects test, the effects standard, has very effectively and in a practical way allowed us to deal with these policies and deal with disparities of the type that Dennis is referring to, economic disparities that result from racial injustice and are connected to racial injustice, to deal with it in a systemic way. And that's incredibly important if we're going to make progress.
Let me also just add, because I'm so happy we kind of got here. I wasn't sure we would get here, but this is really the meat and potatoes of the thing. You have to understand, the history of housing in this country to understand what the Fair Housing Act was attempting to do and why we need all of the tools available in the Fair Housing Act to do it. We don't just wake up and find ourselves in segregated communities by chance. We got there through a series of, as I said earlier, policies and investments at a massive level. If you think about the FHA, and mortgage-backed and providing mortgage insurance from 1934 well into the early 1970s, and having a policy of requiring racial segregation in the mortgages that they insured, requiring racially restrictive covenants. You look at all of the investments that went into creating suburbs that were racially segregated. All of these policies, all of these investments produced the society that we came then to see as segregated. It wasn't by chance. So how do you undo that? That's what the Fair Housing Act was trying to address. Well, one way to undo it is to make sure that individuals cannot themselves engage in discriminatory housing practices. But the other way to undo it is to ensure that policies going forward take account of that history and depart from that history to go another way, to try and reverse the massive investments that went into segregating this country, largely perpetuated by the federal government. That's what we're talking about. So to not see disparate impact, which is a recognition of how we got here and what things look like and the way in which you can perpetuate what was already created, you've got to have that tool. And to not see that as part of it is to take a very narrow view of what housing discrimination really is and what it produced, with all of the collateral effects that both John and Dennis have described in terms of education, in terms of wealth accumulation, in terms of economic access, and so forth. And so that's why when we say it kind of lies at the center, and President Johnson said this over and over again, George Romney, when he was HUD secretary, believed that housing discrimination lay at the center of racial inequality in this country, because it is a reflection of those policies and practices that lie behind the veil, that most people don't think about, that when you walk out into Washington, D.C., or into Baltimore, or into Dallas, you don't think about the policies that went into making those communities appear as they appear today. And that's a huge, ambitious project of the Fair Housing Act. Enforcement of it has not always been the most aggressive, and so we haven't made all the progress that we should have made. But we need all the tools that are available to keep making the progress that we have made.
Any other questions from the room?
Well, you're so persuasive. Why would anyone disagree? I mean, how could...
I often ask myself that question. This is the lot of the civil rights lawyer.
I mean, here you see, quite a huge array of industries and a number of governments and elected officials, fighting to remove something that they feel is inhibiting the development of housing, right? I mean, do you see any merit at all to the other side's position? I know as an advocate, you've got to at least play that game. I mean, what do you think is the strongest argument against your position?
Well, I think the past is one of the strongest arguments. This isn't something new. This is a system that we've been operating under for years, and it hasn't inhibited growth. What it does is it encourages fairness. It gives people an opportunity to have access to some relief. You know, when you think of the examples that I gave of a woman being forced into the horrible position of having to say, if I call the police, I may lose my house. How could we justify taking away the option of being able to address that effectively in the courthouse? And you know, I don't think that there's any convincing demonstration that because of the requirement that things be done fairly and equally, that we're not able to conduct business.
I would go further, and I would say that I think that a lot of the opposition you hear is actually from a very small segment of a very conservative part of the industry and of the political right that is reflexive and unthinking and actually not knowledgeable about all the progress that a tool like impact has caused industry to be able to make. I'm going to be very concrete. Take the lending industry. If you talk to people who are progressive and are thinking in the lending industry, and there are many, not the lobbyists, but the people who are actually on the front lines, engaged in designing underwriting policies and pricing policies and concerned about the bottom line dollars of these institutions, they understand that where underwriting models or policies are designed in a way that focus on both the least discriminatory outcome that still maintains the predictive power of being able to determine who's qualified, who actually is going to be able to pay back a loan, they can make more money because they actually identify more qualified people and they achieve the goal of creating opportunity for people in underserved communities and in protected groups because they're finding policies that have less impact on those groups. At the same time, they maintain the predictiveness of the model. And those entities now, as part of their regular practice, is to engage in regular reviews of their policies and procedures to make sure they have the least impact with the most predictive power. That they don't compromise their predictive power on their models and policies, but they still have the least impact. And they will tell you that they're better because of it. Not morally better, but they may be morally better, but they are better at doing their business. They make more money. It's better for them. They will tell you that. And the people who just engage in the rhetoric haven't actually understood that lesson that business people who are thinking in business understand. And I think that's so important that this debate, however it is thought of and in the chambers of the Supreme Court, as people the justices start to think about what they're actually doing, that this not be about some small-minded view of semantics or some small-minded view based on rhetoric or political ideology. But this is about what's the fundamental purpose of what we're trying to achieve here, as Sherilyn said. What are we about as a society? What are we trying to get to? And what is working? And for goodness sake, judges across the country for the last 4 years have unanimously recognized this works, and it's reasonable, and it's fair. That's why they've all endorsed it. And one only hopes that 5 members of the Supreme Court understand that and understand the significance of being able to maintain this tool as part of the civil rights enforcement.
Is there any middle ground between you win or you lose on this? I mean, is there anything the court can do to modify the doctrine that's not that edges it in some way without either?
Well, I think what Sherilyn originally said on this point is very important. How the court says it, what it says, how broadly it lets it, is going to be very, very important. But it is possible, as in this case, as in any case, for the court to look at the particular facts of this case and say, for whatever reason, something was flawed in the application of impact here, or to send it back on those facts and not reach the broader question of whether it needs to be decided now, whether it's in or out. They could do that. I mean, it's always possible to do that in a case, and that could happen here. But I'm saying, it could happen to Lucas, it can happen in any case.
All right. Well, thank you all so much for joining us today.